Welcome back to the Law News Network, everybody. I'm Jesse Weber. Thanks for joining us. We are cutting out of the prosecution's opening statements in Toledo, the prior testimony, as we wait for live coverage in about a half hour, because we have a very special guest with us to talk about Jessica Chambers and Toledo, the mayor of Mill Valley, California, and an attorney, Miss Jessica Jackson Sloan. Miss Sloan, thank you so much for joining us.
Thank you for having me on.
So my first question to you is, I don't know if you had a chance to hear what we were just talking about, but one of our reporters in the Jessica Chambers case, she got banned by the judge from the county. This just came in. I'll just give you a brief recap. Apparently the judge in this case, and we've talked about this, there's some racial connotations in this case with an African-American defendant and a white victim, but our own producer got kicked out because what happened was the judge gave a white reporter a stalk of cotton, okay? Gave her this as a gift. It's a very weird gift. We just found out about it. So our reporter found out about this, took a picture of it, posted it on social media and said what the judge did. Well, she got kicked out, not only of the courtroom, but of the county, Now, I just have a brief question I have to ask. Have you ever kicked anybody out of a county?
No, I've actually never heard of that happening before. What was the significance of the gift, the cotton?
We do not know at all. We do not know at all what the intention was behind it. All we did was report on it, and we were accused of making a racial slur on social media, which is not the case. We just posted and reported what happened. But as a mayor, I had to ask that as my first question. Have you ever thrown anybody out of a county? Now we know. I don't think it's natural.
No, and of course my jurisdiction only extends to the city level, not to the county level. So I couldn't if I wanted to. But I would, tell your reporter to go ahead and make some notes or write up a declaration on that, because perhaps it'll come in on a habeas appeal as some sort of judicial misconduct or otherwise, questionable activity.
I agree. That's some good advice. And don't worry. You got some time. You could kick somebody out in the future. We'll see what happens. But in the meantime, I do want to talk about, briefly, I want to get to Toledo, and then I want to go back to Chambers. Toledo, this is a death penalty case in the sense that if he is convicted of the deaths of these two young children, he faces the death penalty. I'd like your thoughts on the death penalty, and particularly in this case.
Well, I think this case is an emotionally charged one, right? It's a little bit tricky. There are no bodies in this case, so there's still some questions as to what happened. The evidence that's been presented so far suggests that perhaps there was a homicide that occurred in the house, given that the house smelled heavily like cleaner. There was a knife that was found. It seems there might have been some blood splatter as well, but there aren't any bodies. So, of course, whatever happened is still sort of a mystery. We do have a defendant here who has admitted, supposedly, to confess to killing his girlfriend over an affair she was having. However, he has never confessed to killing the children and has actually said he did not kill the children. I would imagine it's because of the children missing and the presumption that they are dead that they did decide to seek death penalty. But again, this is an emotionally charged case and one that is probably going to weigh heavily on the jury.
What kind of defense does he even have in this case? And we heard the defense's opening argument saying, make a decision after you hear all the evidence. That's all well and good. But really, what kind of defense are they mounting here when this guy it's not looking so good for him?
It's not looking so good. And of course, this is, again, a pretty high profile case. So, it depends how much the jury has heard on it prior to coming and sitting on the jury. So first stage of the trial is going to be whether or not he did it. The defense attorney has asked that, they withhold any judgment, as all jurors should, until they have heard all of the evidence. I think that the credibility of the testimony given by the investigator, the credibility of any witnesses put on by defense is going to be a big part of this case, since there aren't any bodies. There, I'm sure, is some doubt being raised by the defense as to whether or not those children actually are deceased. The defendant's story is that he caught his girlfriend having an affair. He came to her workplace. A fight ensued. The police were called. He left. and that he slept in his car that night so that he didn't have to go in and see her. And when he came back, she wasn't there and the kids were gone. So that's one story. On the other hand, there is a suspicion that she's actually deceased and the children are deceased, and supposedly there's been this confession. So credibility of witnesses is going to play a huge role in whether or not the defense is successful here.
So you think that the prosecution so far is putting on a pretty strong case? I mean, talk about that cleaning supplies. I mean, testifying to that the house smelled like cleaning supplies, that the bloodstains in the house seemed to have been wiped up. In fact, Tyshawn Jackson, who's a neighbor, even testified that when he helped Toledo move Yesenia Suarez's car, he saw him wiping it down. It seems as if the cleaning is almost as much of a pointing the finger at Toledo than the actual crime. And I'm sure in your experience, when you see people trying to clean up a crime scene, and by the way, I'm making an assumption here. I'm just saying that people with the idea of evidence of cleaning up a crime can implicate people in a very strong way. Am I correct?
It can implicate people in a very strong way, especially in the absence of having other evidence that would point in a different direction. The human mind wants to understand what has happened here, right? So if the only explanation for the disappearance of this woman and her two children is she went missing, and now here's the boyfriend who's been, violent or loud and fighting with her, cleaning up aggressively around the house, aggressively in her car, asking people to help him move her car. The natural inference there is going to be that something unusual was going on here and that he was trying to hide a crime. However, it's not a body. It's not hard evidence showing, that he killed anybody. So it's going to be up to the jury to decide whether or not this evidence actually extends beyond a reasonable doubt and shows that he killed somebody.
Well, we're going to have to wait and see. We are in recess in a lunch break right now. It comes back at 1 o'clock. We'll have to check in and see what happens in that case. But I do want to turn our attention to Jessica Chambers. Okay, so right now we are in verdict watch. We just got a report that the jury wants to review parts of the recorded interviews with Quinton TELLIS regarding cell phone data and text messages. The jury is, I think, in about 6 hours of deliberation. That request, deliberating for 6 hours, what can us from the outside, our viewers, what can we make of this?
Listen, and I always love the speculation when the jury is in
It's fun.
deliberations.
It's fun.
It's fun because, again, we're trying to come up with a story for what might be happening. The jury's been given their instructions. They've been given a list of evidence that they have to sort of weigh and decide whether or not it rises to the standard that the prosecution needs to have proven. So at this point, it could be as simple as they're reviewing the evidence. Somebody on the jury had a question, didn't remember it correctly. Two of them maybe disagreed in what their memory of that evidence was. Perhaps they wanted to listen to it as opposed to just reading transcripts because, again, they're evaluating credibility of the witness. It could be a lot of different things, but it could be a sign, that there's some disagreement on the jury as to what the cell phone data means. And again, remembering, this is a horrific crime, but one that actually went unsolved for a period of time. And the cell phone data has been viewed the entire time as central to the prosecution's case.
I agree that the cell phone data really seems to be what the prosecution is hanging their case on. Based upon that data, what we've seen so far, I mean, when I heard the opening statements, I thought that cell phone data is definitely going to implicate Quinton TELLIS. It's going to show that he was with her only moments before this attack or right when we saw it. What I seem to see is that this data shows, yes, they were together, yes, they were communicating. Their phones were shut off at the same time. They seemed to be together right before all of this took place. But isn't it possible someone else could have committed this crime? I don't know if the cell phone data is as strong as the prosecution would like. What do you think about it?
Yeah, I don't think that it ended up being as strong as a lot of us presumed that it was going to be. And then, of course, on the defense side, I don't think that the defense ended up being quite as strong as we thought it would be. Paramedics came to the scene of the accident where Jessica lay, having crawled away from her burnt vehicle and having been so badly burned herself. And when the paramedics actually asked her, what had happened, she said a name and it sounded like Eric or Derek, not Quinton. So the defense really made a big deal and big push on that. However, later some evidence came in that suggested, perhaps because of the degradation of her vocal cords and the amount of damage that she had suffered through the smoke inhalation as well as the burning, perhaps her throat was too swollen and her mouth was too swollen to actually properly form the name Quentin, and that's why it sounded like Eric or Derek. So I think on both sides, there were some very strong claims made during the opening arguments. There was, an idea that the prosecution sort of had a slam dunk case with this data. There was an idea that the defense had a really strong defense with the victim actually saying somebody else's name when asked who had done this. And both sides during the presentation of evidence seem to have lost a little bit of steam in those arguments.
Very interesting. I do want to talk about the Eric and Derek in a minute. I do want to touch briefly upon the prosecution's other evidence that they think is strong. The keys that have Quinton Tellis's DNA on them, does it really have his DNA on them, or does it show that he just can't be excluded from them, and wasn't there other people's DNA on them? And I want to talk about the surveillance footage showing cars leaving and coming from that garage, Quinton Tellis's garage, the shed where the gas canister was. So we have the surveillance footage, and now we have the keys. Does that help the prosecution? Again, I don't think it's as strong as they would have liked.
Yeah, again, it goes to whether or not this evidence will actually rise to beyond a reasonable doubt. So the issue here with the DNA evidence is one that I think highlights a little bit bigger policy question. Whether or not you can, and I'll just take a moment and say, it's funny what juries come to these sort of trials expecting. There are a lot of shows out there, whether it's CSI or NCIS or any of these sort of forensic science criminal trial kind of shows that have built a certain standard in lay people's minds. They watch them, they expect that they're going to come to a trial as a juror and have all of the scientific evidence laid out, and there will not be a question as to identity of somebody if they have DNA, or there will be available DNA, just because that seems to be what society expects. But as it turns out, most county departments don't have that level of technology. That kind of DNA is often compromised. As you said here, it can become a mixture of DNA. So it's really not a slam dunk case in a lot of these cases. And sometimes that actually backfires with jurors who are expecting to be able to see clear-cut evidence one way or the other and are surprised when they're unable to. But the bigger policy question that I think this actually highlights is the lack of access for defense bar to DNA evidence. You have a situation here where the DNA evidence they can't exclude TELLIS from the mixture, but possibly there's other DNA on it, right? If you think about your own keys, how many people probably have touched it, whether it's
no
valet
one. I don't let anyone touch them. Next question.
Well, I've got a 2-year-old who touches it. I've got my husband. I've got the valet. I've got, a plethora of people have touched my keys and come in contact, and their DNA would be in a mixture pool on it. So once that DNA is collected and taken in by law enforcement for testing, in a case like this, they're testing it just against the defendant's DNA. They're not necessarily running it through CODIS, the larger DNA database, to see what other people's DNA are on that key. And that's actually something that the defense bar does not have access to. You can file a motion and request it, but it's not an automatic right. So if there are keys that might have somebody else's DNA who might actually be the killer in this case, the defense is unable to run those keys, that DNA mixture, through the larger DNA database to see if there are hits for anybody else who could be the actual killer and provide an alibi for their defendant.
Amazing, amazing. It's because of the rules that we have. It's so funny. Many people want justice, they want the truth, but a trial sometimes is something else. It's what you can prove and what are you allowed to do. I do want to talk about that surveillance footage, the idea of the cars coming out of the shed or not. We don't know who's driving them. We don't know even precisely what kind of cars, but it does beg the question, the timing of when it happened. Is the timing enough?
Again, that's going to be up to the jury. There's a lot of circumstantial evidence here. There's a lot that could weave a story that implicates Quinton. But at the same time, it's up to them. And there's a lot of pieces of this story that are still missing, which is surprising given how high profile this case was, how many resources were dedicated to it, and how long this case went on before they even had a suspect in custody. So, I think it's up to the jury to decide, but it's certainly an important piece of the story, and one that the jury may actually give some weight to.
What do you expect? How much longer do you think before they deliberate?
You never know. I've worked on homicide trials that went on for 5 months, and it took the jury 45 minutes to acquit them. The jury is their own animal. You really don't have a sense of what they're thinking until they start asking questions, as they have here, and start asking for more evidence. But at this point, I imagine both the prosecution and the defense are eagerly on the edge of their chairs, awaiting a call that they need to come back to court for a verdict.
Why do you think, I've asked other guests that we've had this question, but you specialize in this area, you are very familiar with this area. Why was the death penalty not put forth in this case? Is it the nature of the crime? Is there procedural reasons? Is there expenses? I would like to know from your opinion why you think in such a brutal crime, why the death penalty wasn't on the table here.
It is an extremely brutal crime. I will be honest, I was a little bit surprised that the death penalty wasn't put forth here, but you do raise some policy considerations. So the first consideration you raised is the expense of the death penalty. Whenever you're doing a death penalty case, it's extremely resource intensive. Not only, is there a heightened security, and of course, you want to be a little more careful about the evidence that you're collecting because you've got somebody's life at stake. But there's also 2 trials. There's the first trial, which is the guilt phase, which is whether or not the person is guilty. And then there's the second trial, which is the penalty phase, which is going to decide whether the jury wants to sentence this person to spend the rest of their life in prison, or if they want to give them the death penalty. During that second phase of the trial, the jury has to weigh what's called the aggravation, which in here would be all those horrendous facts that go into this crime, against the mitigation. The mitigation is going to be information about the defendant, who at that point will have been found guilty, about his childhood, about his mental health, about his drug use, about his, everything from the beginning of his life through the moment that this crime occurred, and even his ability to understand, what he was doing when he committed this crime, if he is found guilty of committing it, of course. So there might be some evidence that came through on the prosecution's desk that doesn't go into this phase of a trial, but that indicated that it would be hard to actually get a death sentence if he is found guilty, or maybe there are some compelling reasons there. Another factor I don't think comes into play here, but sometimes does in death penalty cases, is the actual wishes of the victim, the victim's family. Sometimes the victim's family will make a strong statement against the death penalty and say that they are hoping not to have the death penalty sought in a case, and that can influence the prosecution. And then the final piece I'll say that I think, is a major policy reason not to seek the death penalty in a lot of cases is just the extreme length of the process. It's not like, somebody is found guilty and sentenced to death and killed the next day. This is a process that continues and is extremely expensive for the state as they go into a direct appeal, and then years and years of a habeas appeal that are incredibly resource intensive. But it's also a process that is very hard for victims' families to go through. They're asked to come back at hearings. They're given notices when things are filed. It's not a process that allows for any sort of healing or closure, whereas, the goal would be once somebody is actually sentenced, the family is able to, start to focus on healing, put the trial behind them, start to move forward. And I think that more and more we're hearing from law enforcement that they see, this incredible resource waste, as well as the lack of healing that comes from a death sentence, because it's perpetuated by years of appeal, and they're deciding that, it's just not worth it.
No, that makes sense. I wonder if one of the theories that goes in for the prosecution, as well as maybe you said as the family, Do some people believe that life in prison is a worse off punishment than eventually being executed? If you know that he's 29 years old, Quinton, tell us if he's found guilty, the idea that you're the rest of your life, every day you wake up, every second you are incarcerated, is that worse off for someone than actually giving them death?
Well, I suppose that's an individual question. I've heard from people who have been given life sentences. Hey, I'd rather have been given a death sentence. I've heard from people on death row, of course. Hey, at least if I could live in prison forever, I could start to give back and make up for this somehow through my work here in the prison. I do think there are a lot of people out there who are starting to realize that, even in a horrific crime like this, sentencing somebody to the death penalty versus sentencing them to die in prison is a different punishment. While they're in prison, they'll be able to take accountability for what they did. Hopefully, they'll transform themselves, and hopefully, they'll be rehabilitated to some degree and be able to give back to their community.
Before we let you go, I do want to talk about the Eric and Derek issue. Many people say the issue in this case. My concern, and I've heard other people's concerns, are that obviously investigators first went after any Eric or Derek in the community or that was associated with Jessica Chambers, or in this case, they investigated. But what does it mean to rule somebody out? We don't have that full picture about what it means to rule out an Eric, what it means to rule out a Derek. We know that there's Erics and Dereks who are affiliated with Jessica Chambers. That's the biggest concern that I have. It's very simple for investigators to say, oh, we ruled him out, but is just interviewing these suspects enough? What does that mean?
Well, I haven't read all the notes. I imagine some of them had alibis that they were able to prove, places that they were at the time that this crime happened, that would indicate, that they were not actually there at the scene of the crime. There are Erics and Dereks, but again, we have testimony from Dr. William Hickerson, who actually oversaw Chambers' care while she was at the hospital before she passed away. And he testified that, she suffered so much damage to her mouth, her throat, and her chest that she couldn't speak clearly or properly enunciate words at the time of the crime scene or at the hospital. So in a lot of ways, I think this negates the statements made about Eric or Derek in a lot of people's minds and possibly in the jurors' minds.
But couldn't the argument be that she was able to communicate when she was cold? She was able to communicate her own name. Yes, there was a lisp to it. There was a distortion of her name, but she was able to communicate it. She was able to communicate, help me. So first responders understood what she meant there, but when we're talking about the name Eric, Derek, Quinton, TELLIS, it might be hard. It might be a stretch unless, in fact, the person was an Eric or Derek.
Yeah, there's a significant stretch, right, between those different names. When I first heard it, I thought, well, this is sort of a easy case for the defense because you actually have the victim, who is laying there having been tortured and dying from these burns, enunciating the name of the person who she says was responsible. That in most cases would be enough. However, I do think that other testimony came in, and again, it's going to be up to the jury just to weigh the credibility of Dr. Hickerson, to look at all of the statements that were made, to listen to, what the paramedic firefighters said on the scene of the crime, and then to decide. But if they have, I think they had about 10 men who were named either Eric or Derek, according to Tim Douglas, who was from the Mississippi Bureau of Investigation. They had a whole list of people with that name that were in that area and that were cell phone contacts or social media contacts. They interviewed all of them. I understand that none of them were actually asked to submit any sort of DNA evidence to the investigators for lab testing. So again, here's one of those policy highlights, right? If I'm a defense attorney on this case, I would want every single one of those 10 men to have to submit their DNA and have that tested against the DNA found at the crime scene. But again, as the defense bar, even though your client is presumed to be innocent until proven guilty, you don't have access to that kind of testing, and you can't make that kind of request. But Douglas had said that, none of them were tested because they actually were not believed to be suspects, and they had cleared all of them of wrongdoing. I'm not sure what went into clearing them, but perhaps, if he is found guilty, this is a ripe area to look at on appeal.
I was just about to ask you that if he is found guilty, there would be issues for appeal. The strategy, look, this is an issue you couldn't ignore if you're the prosecution, the Eric or Derek situation. You have to address it. What the concern is from people that are watching this case, they say that the prosecution put that fact a little bit too strongly in the beginning. Not only did they mention it in their opening about Eric's and Derek's, but every single first responder that testified, I would say 95% of them said they heard Eric or Derek. Obviously, they have to bring it up, but didn't that hurt their case? Was that a bad strategy?
Yeah, I think you walk a fine line. And of course, I always say for the defense bar, it's easy to sit in this case and this chair and sort of quarterback it. I think for the prosecution too, it's a fine line of having evidence that is going to come in and hurt you or hurt your, case, detract from your prosecution. But at the same time, you want to confront that evidence so that you gain credibility with the jury and so that you have an explanation for it. And you're the one telling them about it and providing an explanation for this discrepancy. But at the same time, you don't want to hurt your case or overpromise and under-deliver. So it is a strategy question. In this case, I would agree with you. The prosecution came on a little too strong in the beginning. Like you said, there are other statements that were made by the victim that were understood that sort of cut against the theory that her mouth was toothed one way or the other. But the prosecution, I believe, really wanted to kind of deal with this bad fact for their case right up front to gain some credibility with the jury, but in doing so might have actually hurt themselves.
I don't know if you had the opportunity to see, but yesterday it was the closings, and the prosecution was offered a rebuttal, and they did a rebuttal closing, and they said, okay, I just want to address the Eric and Derek again. Eric or Derek, it could sound like TELLIS, and she didn't pronounce Chambers so right. The prosecution seemed like on the defensive about that point. They're like, okay, I know the defense keeps bringing it up, but let me try to re-explain it again. Obviously, they're trying to get the last word in the jurors' minds, but it seemed like from a weak position. And, rebuttal arguments, if you can just speak a little bit about that, rebuttal closing arguments, what do you make of those? What do you need to do and what do you not need to do, which might make your case look weaker?
I think you hit the nail on the head here. Continuing to drive home this point that's already been dealt with, it's already been put out there, the jury's already heard it, continuing to harp on it when you have a case that's actually, not the strongest case, given the cell phone data didn't come through as strongly as they had hoped, the DNA doesn't come through as strongly as they had hoped. They have a horrific crime scene. They have a victim who is extremely sympathetic. But at the same time, they don't have the strongest scientific evidence as they would like to and as they had claimed to have in the beginning. So I think, in some ways this indicates that the prosecution was nervous about this fact in particular and wanted to provide the jury with a reason behind it and just make sure that they got the last word on that.
Jessica Jackson Sloan, attorney and mayor of Mill Valley, California. Thank you so much for joining us to talk about both of these cases. Will I be invited to Mill Valley? Can I come check it out?
Absolutely.
I've never been.
Come on out. I'll show you around.
Great. As long as you don't kick me out of the county, as long as you don't kick me out of the city, as our producer got kicked out of the county in Panola County.
I've never kicked anyone out.
Well, good to know. Thank you so much for joining us. We'll make sure to have you back on to talk about this case and as others as they develop.
Thank you so much.
Thank you. So we actually are waiting right now. I think the Toledo courtroom is